All right. So the first session is about procedure at the hearing, how the hearing is being conducted in the arbitration. We all know there is a clear demarcation between the arbitration proceeding and the court proceeding. Court proceeding, it is completely adversarial. But arbitration, the arguments will be not that much. Arbitration is all about document submission, how you are drafting your documents and how you are submitting your document. And it is mostly based on the factual matrix. More you rely on the factual matrix, your success prospects is more. It is as simple as that. So with that prelude, let us go into the hearing, how it is happening. So hearing is nothing but presenting your perspective, whatever, allows the parties to have a reasonable opportunity to present their case. The burden of proof to be discharged is the civil standard. That is on the balance of probabilities. So that is the main difference between civil case and a criminal case. In the criminal case, there should be 100% proof should be there. If any accusation is leveled, that should be proved beyond doubt in 100%, it is not 99% also. However, in the civil proceedings, which includes arbitration, it is based on the balance of probabilities. What is that? It all depends upon the evidence you are producing, the adjudicating authority, whether it is an arbitrator or a mediator. What he will do, of course, mediator will not decide, arbitrator. He will weigh the evidences in front of him. And there is no need for 100% substantiation. It is based on the balance of probabilities, which is weighing more. So accordingly, the decision will be arrived at. So therefore, the hearing is nothing but the opportunities for the parties to present their case, to present their arguments. Because in the arbitration, it is all about document submission. So therefore, there will be voluminous documents. It is essential to make it palatable to the arbitrator. So that is what the objective of hearing is. During the hearing process, it is the greatest opportunity for the parties to submit a palatable case to the arbitrator, to make the arbitrator's job easier. End of the day, it is a perspective, how you are conveying your perspective to the decision maker. Sometimes you may have the very good entitlement, but if you don't convey it properly, then you don't run a chance. It is as simple as that. So that is the objective of hearing process. So there are several types of hearing. Partial oral hearing may also be held with only one or two issues dealt with the person before the arbitrator, and the rest being by documents only. That is how most of the arbitration will happen. The number of hearings will be very less, unlike your civil court proceedings, where even though you submit voluminous document, the number of hearings will be more. Sometimes oral hearing may be held by the arbitrator to deal with the documents only reference by meeting with only the experts, especially in the construction arbitration. So before the hearing is conducted, there will be preliminary meeting. We all know that. The objective of preliminary meeting will be to decide the dates and length of hearing. Okay. And then venue, times the arbitrator will sit, representation and list of attendees, all these things will be decided. Production of agreed bundles, how the documents will be submitted, timetable for exchange of document, witness, So this is about preliminary meeting. And then opening submission, who will open the submission, order of witness. So it will be like first the claimant, he will produce his witnesses. Once he produces his witness, the opposite side respondent, he will do cross-examination. Similarly, the next turn will be to the respondent. He will produce his witnesses, which will be cross-examined by the claimant's team. And once that is done, then the issues will be listed out. Issues are nothing but questions to be answered in the case. So arbitrator's duty will be to find the answers to the issues. Where he will find the answers? He will find answers from the documents. He will find answers from the arguments. And he will find answers from the validity of the witnesses and evidences produced. Okay. Then he will start preparing the award accordingly. Okay. So the arbitrator, he should remind the parties about his power to deal with any preliminary issues. Okay. So preliminary issues, what are the preliminary issues? Most of the arbitration cases, the respondent, if he is weak, if his case is weak, then they will raise two issues as preliminary. Number one will be jurisdiction. They will say arbitrator, he doesn't have the jurisdiction to decide the case. Second thing, what they will say, ineligibility of the arbitrator. That also they will raise. So these are called preliminary issues. So as soon as the hearing started, the arbitrator is bound to decide on the preliminary issues. But again, in the practical sense, what happens? Arbitrator, he will reserve these things towards the end because it is the arbitrator's discretion. For obvious reason, suppose if there is some gray area about the jurisdiction, and if he takes it as a first issue to decide, fortunately, unfortunately, if he finds that he doesn't have the jurisdiction, what will happen? The proceedings will be aborted, isn't it? End of the day, he will lose his fee. He will lose the opportunity to get the fee, isn't it? So that is why arbitrators, what they will do, okay, I will decide, I will reserve it towards the end of the proceedings. That's what they will do. So in the hearing, what will happen? First, arbitrator, he will commence by introducing himself and each of the parties, so that names of the all present are noted. Why? That is the prerequisite. Every meeting should be recorded point by point. Who all attended? Whether it is claimant himself or their representatives. Whether they are the authorized representative, that is very important. Okay. So for that matter, first he will introduce himself and he will ask the parties. And he will ask them to validate also. So that they call it as authorization letter, power of attorney. In India, they call it as wakalatnama. So that is the power to represent. That must be there. Okay. If you are an arbitrator, first you must check whether the parties are real, whether the parties are authorized. If you don't check that, then there is no meaning of arbitration proceeding. So that will be the first thing he will do. He will validate the parties in front of him. And that will be recorded. That will go into the record. And then he will remind the parties of their general duty to comply with the procedures. In the sense, the submission, the timeline, okay, and the conduct of the parties. Arbitration is not a civil court proceedings. Okay, there is no room for adversarial fight. It is a kind of a gentleman's game. Okay, so there is no room for tactics of war. It's all about documents. It's all about factual matrix. Then at the start of each session of the hearing, before commencing, arbitrator, he will run through what are the pending matters in the previous hearing. Suppose in the previous hearing, towards the end of the hearing, one of the parties, he must have made some request for some document disclosure, because that is another unique feature of the arbitration. That is the unique feature of the construction arbitration. Since you're all commercial people, you may know that either the contractor, mostly the contractor, they may not have privy to certain documents, which only the employer must be having. So therefore, the contractor, he has the right to request the arbitrator to ask the employer to make a disclosure of certain document. So such request will be dealt in the beginning. Outstanding administrative issues. And then he will allow he will allow claimant to start the arguments. So that is the order. First, he will invite the claimant and then respondent, and then he will give one more chance to the claimant. So that is the order. Then he will call witnesses. Usually, party first followed by witnesses of the fact, followed by any expert. Okay. So that is the order for the witnesses. Fact witness, expert witness. Just to refresh, what is fact witness? What is expert witness? Fact witness is the one who is associated with the company or the project during the life cycle of the performance. Whereas expert witness, he should not be associated with the company or the project. He must be truly independent third party. Okay. So first fact witness will be called and then expert witness will be called. So even the fact witness and expert witness, during the proceedings, there are substantial difference in the hearing process. Fact witness will be subjected to adversarial cross-examination. If the fact witness is produced by the claimant, the respondent, he will try to discredit their character first. Whereas for the expert witness, we people, techno-legal people, they will be treated on the same, they are on par with the arbitrator. Okay. So expert witnesses may be deferred until the end of the respondent's case. It helps that evidence of both the experts can be compared more closely by the arbitrator. So there will be expert conference will be there. Hot dubbing will be allowed. You may all know what is hot dubbing. Hot dubbing means both the experts of the parties, they will sit together and they will try to eliminate the issues which are agreeable. And then they will shortlist the issues to be discussed and they will produce a joint report which will be given to the arbitrator. That will help him to come to the conclusion. Okay. End of the day, arbitrator is not bound to go with the expert witness opinion. So at the end of the hearing, respondent will give his closing submission followed by the claimant. That's what I told, claimant will be given one more opportunity. After the arbitrator has checked that there is no further evidence, he will close the hearing. He will reserve a date for pronouncing the award. Okay. Okay, now how you will prepare for a arbitration hearing, whether you are a claimant or respondent. First, you must understand the arbitration agreement word by word. Arbitration agreement or arbitration clause, that is the source of many things. That is the source where the arbitrator, he takes his power. Arbitrator is the product of the contract. Especially, he is the product of the arbitration agreement. Because based on the arbitration agreement only, the arbitrator will be chosen. Okay. So therefore, the party, he must be 100% familiar with the arbitration agreement. That will give you the confidence. Suppose if the respondent, if he contest the jurisdiction, and if you are confident about your arbitration agreement, then you can defend easily. Then understand the applicable rules. Okay, rule is different than the law. So in any arbitration case, arbitration law and arbitration rules will be applicable. Okay, arbitration law is nothing but substantial matter, whereas rule that gives the direction of how the arbitration should be conducted. Okay, for example, the arbitration law, it will state about the sequence of the arbitration proceeding. First, the document submission, and then hearing, and then evidence and issues, final submission, award, etc., etc. Whereas the particular rules, suppose if you are saying this arbitration, so-and-so arbitration will be conducted as per the DAAC rules. So if you look at the DAAC rules, that will specify how each and every stage should be conducted. For example, the hearing is conducted, hearing is complete. Now, it is the arbitrator's duty to produce the award. So here, the arbitration rules come into play. The rule will stipulate that the arbitrator, he must produce his award within 30 days or 60 days. So therefore, both the parties as well as arbitrator, they must understand the applicable rules completely. Okay. Suppose if the arbitrator, if he fails to track the timeline, then his mandate will exhaust without his knowledge. He will not have any power to decide. Suppose if the arbitration rules, it says that arbitrator, he must produce his award within 60 days from the date of completion of the hearing. And if he fails to track that, on the 61st day, he will not be arbitrator. It is as simple as that. So therefore, the rules, it must be understood clearly, and that should be tracked, for any non-compliance. Conduct preliminary research and gather information. That is very important. Before going into the arbitration, we should generate factual matrix. That is the first duty, whether you are a claimant or respondent. We should do the research and generate factual matrix. That is what we will do. What is the factual matrix? It's all about the important key dates. Dates in the sense, commencement date. You have two types of commencement date, isn't it? Effective date and then actual commencement date. Drawing submission date, mobilization date. When the approval was done, what is the actual planned date? What is the planned date? What is the actual date? when the program should have been submitted, baseline program. What are the key dates for the updating of baseline program? What are the milestone dates? If the milestone is not complied, what are the remedies in the contract? So all these factual matrix that should have been generated from both the perspective. So that kind of research should be thorough. And then we should know our arbitrator. That is very important, isn't it? Then we can prepare our arguments accordingly. If you are a counsel, then you have to prepare your client. Okay. You should tell him what is the worst case scenario. And then, we need to prepare our drafting accordingly. Okay. And it is very, very essential to draft the opening statement. The opening statement, it's a kind of essence of what you are going to prepare in the next, say, thousands of pages. That opening statement, one paragraph, that should have the essence of what you are expecting from the arbitration case. So the success of any case is depending upon how you are making the opening statement, whether it is a drafting or in the hearing. Okay. Because, whether it is arbitration or litigation, it is how you are impacting the decision maker, how you are impacting the decision maker's perspective. Okay. So it is as simple as that. And then hearing day. Normally what will happen? People, they will keep n number of cases and they will forget the hearing date also. That should not be the case. We should prepare at least a week ahead before the hearing date. Then only you can present confidently. Okay. So from the arbitrator point of view, he must give fair chance to all the parties to make their case. And then arbitrator, he should exert control over the hearing, okay, its progress, and he must ensure witnesses are treated courteously. Also, he must be conscious about controlling the cost. He should act fairly between the parties. There shouldn't be any bias between the parties. Everything should happen in front of the parties, not in the absence of one of the parties. That should be the severe ground for the setting aside. Okay, my colleague, she will explain. Arbitrator, he must act confidently, first of all. Okay, there shouldn't be any timid approach. The timeline should be enforced strictly, otherwise he will be in trouble. He will lose his mandate. Okay, stay alert. He must listen attentively. He should not be fixed in his opinions. Okay, he should not decide anything based on his opinion. It should be based on the submissions. He should reserve his opinions and listen openly until all evidence has been presented. Okay, so this is what all about the hearing in the arbitration. Okay.